Pepsi put a price on a military fighter jet, and the price was 7 million soft drink points. John Leonard noticed something Pepsi apparently had not worried about. Those points could be purchased for 10 cents each. That turned a combat aircraft worth roughly $23 million into a $700,000 redemption. Pepsi said the jet was an obvious joke, while Leonard arrived with the required paperwork, points, and an extremely real check. The question was not whether the commercial was ridiculous, because it plainly was. The question was whether a company can display a precise price, publish redemption rules, and then escape by saying nobody should have believed it. Pepsi's promotion was called Pepsi Stuff, a loyalty program built around specially marked packages and branded merchandise. Customers collected Pepsi Points and exchanged them for things like shirts, sunglasses, jackets, phone cards, and a mountain bike. The television commercial presented this arrangement with all the restraint normally associated with multinational soda advertising. A teenager prepared for school while military music announced each item he was wearing. His t-shirt cost 75 points, his leather jacket cost 1,450, and his sunglasses cost 175. Then, the commercial moved outside the school, where students looked up as something powerful approached. Papers flew through a classroom, people scattered, and a Harrier landed beside the bicycle rack. The teenage pilot opened the cockpit without a helmet, held up a Pepsi and said, "Sure beats the bus." On screen appeared the words Harrier Fighter and 7 million Pepsi Points. There was no just kidding on that version of the commercial. There was, however, a reference to the Pepsi Stuff catalog, and that catalog would become far more important than the aircraft. Leonard lived in Seattle, where Pepsi had tested the promotion before taking it nationwide. He first considered collecting the points through Pepsi products, which was ambitious in the way crossing an ocean by drinking it is ambitious. The court later calculated that earning 7 million points that way could require about 190 Pepsis every day for a century. Leonard therefore studied the catalog rules instead of attempting beverage-based immortality. The rules allowed customers who lacked enough points to purchase additional ones for 10 cents each. An order still needed at least 15 original Pepsi points, but the rest could be bought with money. 7 million points, therefore, had an apparent cash cost of about $700,000. Leonard also knew the jet itself was worth roughly $23 million. He did not treat that gap as proof of a joke. He treated it as the entire opportunity. Through acquaintances, Leonard raised about $700,000. He filled out the official order form, writing 1 Harrier jet into the item column and 7 million into the points column. He enclosed 15 original points and a check for $708.50. His accompanying letter said the money was being used to obtain the new Harrier advertised in the commercial. Pepsi's fulfillment company returned the check. Its response explained that the jet was not in the Pepsi Stuff collection, the catalog, or the order form. Only catalog merchandise could be redeemed, it said, and the Harrier had appeared merely to make the advertisement humorous and entertaining. Pepsi also enclosed free product coupons, which is a bold substitute for a vertical takeoff attack aircraft. Leonard's lawyers rejected the explanation and formally demanded delivery. The advertising agency behind the commercial replied that no reasonable person could believe Pepsi was genuinely offering a Harrier. At that point, the dispute stopped being a clever redemption attempt and became a contract case. Leonard's argument had more substance than the phrase "man sues Pepsi for jet" suggests. The commercial gave exact point values for real products and displayed the Harrier in the same visual format. It did not label the aircraft imaginary, impossible, unavailable, or excluded. The publish rules also allowed customers to purchase missing points, which made 7 million difficult but not unattainable. Leonard argued that he had performed the requested act and accepted a public offer. Contract law does recognize some advertisements as binding offers, especially when they make a clear promise in return for a specific performance. A company cannot necessarily announce a reward. Watch someone complete the stated condition and then discover that humor was its preferred accounting method. Leonard also emphasized that Pepsi's private intentions did not control. Contract formation is generally judged by outward words and actions, not by whatever executives silently meant inside a conference room. If a reasonable viewer would understand the message as serious, calling it a joke afterward would not erase the promise. Pepsi's strongest answer began with the ordinary rule for advertisements. Most advertisements are invitations for customers to submit orders, not commitments to sell unlimited quantities to everyone who responds. A binding public offer usually needs unusually clear language, definite terms, and some indication that completing the stated act finishes the deal. Pepsi said its commercial did not do that. It directed viewers to the catalog for the actual merchandise and redemption process. The catalog listed 53 available items, and a Harrier was not one of them. Its instructions said merchandise could be ordered only through the original order form. Leonard had to write the jet into a space where Pepsi had never listed it. Pepsi also argued that the setting made the joke unmistakable. The aircraft landed at a school, blasted papers through a classroom, stripped a teacher to his underwear, and parked beside bicycles. Its teenage pilot appeared more concerned with his hair than with operating a military aircraft over a residential neighborhood. The absurdity was not hidden in fine print. It was the commercial. The litigation itself wandered through New York and Florida before returning to a federal court in New York. After several years of procedural fighting, Pepsi asked the judge to decide the case without a trial. This was a motion for summary judgment, meaning Pepsi argued that even accepting the relevant facts, Leonard could not win under the law. Leonard wanted a jury, including people from the adventurous Pepsi generation, to decide how the commercial would be understood. The judge concluded that the advertisement could be evaluated objectively without sending the question to a jury. That distinction matters because the famous result was not a jury verdict against Leonard. It was a judge's ruling that no reasonable fact finder could treat this particular commercial as a serious offer. The first decisive issue was whether Pepsi had made an offer at all. An offer is not merely an attractive proposal or price displayed on a screen. It must communicate a present commitment to be bound once the stated method of acceptance is completed. The judge found that the commercial instead invited viewers to use the catalog and submit orders under the catalog's terms. The missing jet entry, therefore, was not a minor technicality. It showed that the document controlling redemption did not contain the supposed bargain. Leonard admitted that he noticed the jet was absent from the catalog, but said this did not change his understanding. The court's response, in substance, was that it should have. There was another problem with treating the commercial as a literal offer to the entire public. It contained no language limiting the number of jets, identifying available inventory, or saying that the first qualifying customer would receive one. Without such limits, a mass advertisement can expose a seller to more acceptances than it could possibly fulfill. That is one reason courts normally treat advertisements as requests for offers, rather than offers themselves. Leonard's order was therefore not an acceptance that automatically created a contract. It was at most an offer from Leonard that Pepsi remained free to reject. The second decisive issue was what an objective, reasonable person would understand from the entire commercial. Here, Leonard's sincerity did not decide the case. Pepsi's internal claim that it meant to be funny did not decide it either. The judge examined the ad itself, including its martial music, exaggerated school arrival, casual teenage pilot, and destructive landing. The court also considered the enormous difference between the jet's value and the cost of the points. Buying a roughly $23 million combat aircraft for about $700,000 looked less like a promotion than a warning from arithmetic. Viewed as a whole, the judge found the Harrier sequence was clearly an exaggerated adolescent fantasy. No reasonable person, the court concluded, would understand Pepsi to be promising actual fighter planes as loyalty merchandise. A third legal obstacle concerned the statute of frauds. A sale of goods at this value required a sufficient written record signed by the party being charged, meaning Pepsi. The televised commercial was not that signed writing, and Leonard's completed order form carried no Pepsi signature. Even if he had overcome the advertisement and reasonable person problems, the alleged agreement still failed that requirement. In August of 1999, the court granted summary judgment to Pepsi. Leonard received no JIT, no damages, and no finding that Pepsi had breached a contract. Pepsi had returned the check rather than cashing it, so the $700,000 was not a purchase price the company kept. Leonard appealed, but the Federal Appeals Court affirmed in 2000. Its opinion was brief and adopted substantially the district judge's reasoning. The appeal did not revive the claim, order a trial, or produce a settlement that changed the legal result. The ruling did not establish that advertisements can never create contracts. A sufficiently clear advertisement can still become an offer when it identifies the promise, the required performance, and the limits of acceptance. Nor did the ruling create a universal defense allowing companies to label inconvenient promises as jokes. The test remains objective. So a hidden intention to be funny is useless when the public message reasonably communicates a serious commitment. Pepsi won because this commercial, read together with the catalog and its absurd setting, did not communicate that commitment. The case is remembered for the aircraft, but the most damaging evidence against Leonard was an ordinary merchandise form. Pepsi also changed the advertisement after the demand. One revised version raised the price from 7 million points to 700 million. Another added the words, "Just kidding," finally installing the clarification that had been missing from Leonard's screen. Leonard argued that these changes suggested Pepsi had recognized a problem with the original advertisement. The judge treated them differently because later caution did not alter what a reasonable viewer would have understood earlier. The revisions were practical risk control, not an admission that a contract had existed. Decades later, the story returned through a documentary and then through another airline's loyalty campaign. In 2026, Frontier Airlines used Leonard's experience in an advertisement and awarded him 7 million Frontier miles. Frontier described the miles as enough for him to fly free for the rest of his life. It was a marketing gesture, not a Harrier delivery, and not a reversal of Pepsi's court victory. Still, the symmetry was unusually tidy. Leonard never converted 7 million Pepsi points into a fighter jet. 30 years later, he converted the legend of those points into years of flights on ordinary passenger jets. The law's answer was never simply that advertisements are jokes, or that fine print defeats everything. It was that promises are judged as complete communications, including their words, context, documents, and method of acceptance. Pepsi displayed the most memorable number in the commercial, but the catalog supplied the legally important one: 0 Harriers available.